Well, good morning to all of you. Welcome to Vanik YouTube classes. Today we shall discuss one of the important chapters in Indian polity, governance and social justice, that is fundamental rights in the Constitution of India. Okay, fundamental rights are considered to be lifeline in a democracy. They are lifeline in a democracy because democracy exists only on the flourishing conditions of fundamental rights. Unless fundamental rights are there, there cannot be any democracy. Okay? Therefore, Constitution has made all-out effort to provide fundamental rights in detail. Fundamental rights in detail. It is being inspired by the USA Constitution, and also the Universal Declaration of Human Rights has profound impact on the enumeration of fundamental rights in the Constitution of India. There was some efforts before independence to provide fundamental rights to the people. The Swaraj Bill made by introduced by Bal Gangadhar Tilak in 1895 probably had the first documentation of fundamental rights in India, and there had been many efforts to make provisions for fundamental rights and before independence, but there was no such fundamental rights before independence under a colonial government. Many stalwart statesmen and political leaders conceived the idea of fundamental rights, and Indian National Congress in its various sessions in 1929-30 made a resolution for fundamental rights. So therefore, when the Constituent Assembly met, it put focus on enumerating providing various fundamental rights in the Constitution in details. One of the unique characteristics of fundamental rights found in the Constitution of India is that it is more elaborate, more detailed than any other constitution in the world. Okay, so we'll deal with these questions. Take this chapter very important because analyze this chapter, and also there are certain various issues relating to this chapter on freedom of speech and expression, right of freedom of movement, association, right to equality or rule of law. All these things needs closer analysis for your examinations. Look at the following questions. Consider the following statement. In view of Article 20, the Constitution of India, no person accused of an offence can be compelled to give its signature or thumb impression for identification, give oral testimony in or out of the court. The protection under Article 20 is available both against criminal and civil proceedings. Let us examine that in Article 20 there are three protections are there. It is protection against ex post facto law, protection against double jeopardy, and protection against self-incrimination. So under this self-incrimination, a person can be compelled to give its or her thumb impression for compulsory signature where it is essential. So it is wrong in this statement. It can be compelled. Give oral testimony, that is right. He cannot be compelled to give oral testimony either in or out of the court. The protection against under Article 20 is available only for criminal offences, not for civil proceedings. So statement 2 is correct. B. Okay. Now we'll come to question number 2. Consider the following statement: in writ of mandamus is available not only against judicial authorities but also against administrative authorities. Yes, it can be lower courts. So can be quasi-judicial tribunals. It can be issued. Mandamus means we command. It is issued for against negligence of duties or non-performance of duties by public authorities in official capacity. So that is right. Statement 1 is right. The writ of prohibition is issued against judicial and quasi-judicial. Yes. So both 1 and 2 are right. So writ power is a power given to the Supreme Court under Article 32 for enforcement of fundamental rights, and Article 226 also contains writs or confers writ power on the High Courts of India. High Courts in India, they can issue writs not only for the enforcement of fundamental rights but also for the enforcement of other ordinary laws. So therefore, it is a given power. Parliament can confer writ jurisdiction, writ power to any other court. So far, it has not made this arrangement. So that is C. That is C in the 2. Okay. Next we'll come to question number 3. Consider the following statement: there is no provision in the Constitution of India for reservation in the matter of promotion in the services under the state in favor of scheduled caste and scheduled tribe. There is a provision under 16(4)(a), promotion in the reservations. So that is wrong statement. In Article 16(4)(a), there is a provision for providing reservations, although Supreme Court has not approved it in its judgment, but still government continues to do it in order to provide adequate representation to the backward classes as directed in the Constitution under Article 16(4). So therefore the statement 1 is incorrect. So under 16(4)(a), there is a provision for providing reservation in matters of promotion with consequence or seniority to any class or classes of post in services under the state in favor of scheduled caste and scheduled tribe, which in the opinion of the state are not adequately represented in the services under the state. And that was provided by 77th Amendment Act 1995. But in Indira Sahni versus Union of India 1992, the Supreme Court held that reservation cannot be extended in matters of promotion. The interest of SC and ST will be harmed by the Supreme Court decision. So therefore the government continued with the provisions and there is reservation. Statement number 2. As per the provisions of the Constitution of India for getting reservation for the appointment and post under the state, a class must be backward class and should not be adequate. Yes, that is correct. So answer 2, B is the answer. Further, reservation in backlog of vacancies. There is also a provision provided by 81st Constitutional Amendment Act 2002. In 81st Constitutional Amendment Act 2002, the Supreme Court the Parliament provided reservation for SC and ST in the backlog of vacancies. That means the vacancies will not be counted under 50% slab. So that is also 4A, some 16 for A. 16 for A and 16 for B. These are related to methods of promotion in reservation. Okay. Next we'll come to question number 4. These are all previous year questions for your enhancement of your idea how to deal with the UPSC and OPSC questions. Therefore, we are providing with the help of previous year questions from different years, recent years. I hope this will definitely help you to enhance your base of understanding. So we'll start to question number 4. Freedom of speech and expression include the freedom of press. Okay, so that is correct. It is an inferred rights under Article 19(1)(a). 19(1)(a). Freedom of conscience include the right to wear and wear grievance. Yes, Article 25. Right to personal liberty include right to carry on trade. No, there is a freedom under Article 19(1)(g). Article 19 clause 1 subclause G contains freedom to carry on any trade or business, practice any profession, and freedom to carry on any trade or business or occupations. So that is the correct answer C. It is incorrect. Right to equality includes principles of natural justice. Maybe. Right to equality includes natural justice, that is inferred by the Supreme Court. Okay. Now we come to question number 5. Okay, that is their arbitrariness. Right to equality includes principle of natural justice, and that in order to forbid arbitrariness of the state, so conformity with the rules of natural justice is considered essential for avoiding charge of arbitrariness. So 6. Next, Article 22 of the Indian Constitution, with the exception of certain provisions stated therein, what is the maximum period of detention for a person under preventive detention law? It is 3 months. The preventive detention under preventive detention law is maximum 3 months. Maximum 3 months, yes. and with exception to certain provisions therein means, that means the advisory board an advisory board can be established to ascertain whether the person will detain beyond the prescribed 3 months or not. So there are certain exceptions in this regard. So the protection available under Article 22 clause 1 and 2, clause 1 and 2 are not available to any person who is arrested or detained under a preventive detention law. So preventive detention law is not well defined in the Constitution. Only it is said under Article 22 clause 3 that the protection under Article 1 and 2 will not be available to a person who is an enemy alien and who is arrested or detained under any preventive detention law enacted by Parliament or state legislature. And 22.4 said that 22 clause 4 expresses the 3-month limit subject to revision by an advisory board. So preventive detention law is considered to be a necessary evil in Indian political system, but they are essential to resist anti-national and social forces and to ensure rule of law. So it is 3 months. B. Okay, question number 5. Look at question number 6. Which of the following are true with regards to the fundamental rights of the minorities in educational institutions? Minorities are not well defined in the Constitution. Minorities are not well defined in the Constitution. But the Constitution recognizes minorities on 2 bases. One is religion, another is language. Article 2930 especially deals with minorities. And Article 350A and 350B also deal with linguistic minorities. So the minorities are well protected under the Constitution of India. Although the word is not defined who constitute minorities. And Supreme Court has said that minorities should be enumerated and listed at on national basis. Okay. So minority has only the right to administer educational institution. The word only is wrong here, because Article 30 empowers the minority groups to establish and administer the educational institutions. So look at the option number 2. It is right to establish and administer. It's correct. Right is absolute, not subject to interest. Nothing is absolute in Indian Constitution, first of all. Everything is subject to certain limitations. Mostly. So you cannot say, although the minorities have freedom to establish their own educational institution and run according to that, but they are subject to law made by Parliament and state legislatures. They are not above the state. They are not above the state. In fact, no one is above the state. No one is above the law. So that is wrong. Reasonable restrictions may be imposed to promote efficiency and prevent yes. So answer will be 2 and 4. Correct. B. Okay. Okay, question number 6, question number 7. As far as the armed forces are concerned, the fundamental rights granted under Article 14 and 19 of the Constitution are not available at all. We cannot say that. They are restrictions. They are not completely denied. Above all, they are the citizens and they have all the rights. But they are not available at all is wrong statement. Available to the armed forces but not to others. No. Equally available with certain restrictions to both armed forces, paramilitary forces, intelligence services, police and other analogous services. Available only at the discretion. No one is given the discretion. Available only according to law made by the yes. This is the best option or the right answer. They are available but subject to restrictions by parliament, laws made by, for example, Army Act 1950 poses some restriction for the armed forces, army, and there are Air Force Act, there are Navy Act, there are Police Forces Restriction of Rights Act. There are a number of acts enacted by parliament to fund this purpose. Then we'll come to question number 8. Which of the following right is not explicitly mentioned in fundamental but has been upheld to be so by several pronouncement of the Supreme Courts? Equality before law is explicitly provided under Article 14. Right to non-discrimination public is explicitly provided in 1914. Article 16. Right to form association is also provided in Article 19. Article 19 1D, and it is 16, it is 14, but freedom of press is inherent in 19(1)(a), not explicitly provided by the Indian Constitution, but it is upheld to be so fundamental by the Supreme Court in various cases. So once again, D will be the answer. D. Kindly remember the answer is D. So that is right to freedom of press. Next question will come to, which of the following statement is correct of the writ of prohibition? It is an order issued by the High Court commanding a lower court to cease from, stop from proceeding in some matters not within its jurisdiction. Yes, that means excess jurisdiction. If a court, lower court, has resorted to excess jurisdiction, that is, he has used a power, it has used a power which is not under its jurisdiction, then prohibition is used. It can be claimed by an aggrieved party as a matter of right. No. It cannot be claimed as by an aggrieved party as a matter of right. It is a legal matter. So this cannot be it cannot be provided. Okay, now we'll come to question number 10. So that is answer will be B. Just a minute. Next question will come. Find out the answers from the given below. There are various cases. There's various cases are given here. That is Indira Sahani case, 1992. Indira Sahani case, 1992. Minerva Mill case, 1980. Ike Gopalan case, 1950. And your Sankari Prasad case, 1951. Okay, and look at the matter. 1951, and your A.K. Gopalan case versus State of Madras, 1950. Yes. So in Indira Sahni case is related to Indira Sahni's case is related to reservation of backward classes, in which the Supreme Court held that reservation cannot exceed 50%. Minerva Mill case related to revival of judicial review, which was taken away by the Parliament in 42nd Amendment Act 1976. The revival means in the Kesavananda Bharati case, it was held that judicial review is a part of the is a basic feature of the Constitution that cannot be done away with, cannot be tampered with by the Parliament. But with the 42nd Amendment Act 1976, the amendment of related to DPSPs cannot be judicially reviewed even if they violate fundamental rights. DPSPs even if they violate fundamental rights, that was held. But in Minerva Mill case, the Supreme Court said that judicial review is a basic structure, part of the basic structure, and it cannot be taken away with. And striking a balance between fundamental rights and DPSP is a basic structure of the Constitution. That is there. And in Gopalan case, it was held that, so Minerva case is related to the uphold of judicial review. In Gopalan case, it was held that Article 21 is based upon procedure established by law, not due process of law. So it restricted the ambit of Article 21. But later, in Maneka Gandhi versus Union of India 1978, the ambit of Article 21 was expanded, and the Supreme Court included due process of law as practiced in USA as a part of Article 21. And in your Sankari Prasad case, it was held that Parliament can amend the fundamental rights like any other part. What will be the answer? 3, 4, 2, 1. Yes, A. Next is 11. Under Indian Constitution, which one of the following is not a specific ground on which state can place restriction on freedom of religion, freedom of conscience, freedom of profession, freedom of practice, freedom of propagation are found mentioned in Article 25. They can be restricted on public order, morality and health, so social justice is not there. So we will take the answer as C as the answer. The reservation of seats in educational institutions in favor of scheduled caste, scheduled tribes are given in 16.4. B. 16 clause 4. Is it clear? And 16.6 also provides EWS reservation. That was added by 102 Constitutional Amendment 103 Constitutional Amendment 2019. So 16.4 and 16.6 related to reservations. Okay, is this discussion going on well? Is it acceptable to all of you? I hope so. Okay, now go on to question number 13. The Supreme Court has increased the ambit of right to life to include which of the following? Right to live with dignity, yes, that is Maneka Gandhi case. Right to livelihood is there also. Right to receive minimum wages. No. Right to life includes. So, okay. So right to receive minimum wages is also will be there, but right to guaranteed employment under 100 days is not there. That is a statutory provision under Mahatma Gandhi National Rural Employment Guarantee Acts. But yes, the right to life in India includes the right to receive minimum wages. The Supreme Court interpreted the right to life under Article 21 of the Constitution encompass the right to live dignity, which includes the right to receive minimum wages. So that will be 1, 2, 3 answer. C. Okay. "14. The following statement about the right to freedom of religion is not correct. Not correct. The state can regulate economic, financial, political and other secular activities which may be associated with the religious practices. Restriction can be imposed on the right to freedom of religion on Okay. Funds appropriated by religious denominations for promotion or maintenance of particular religions are taxable. Every religious denomination, this is correct. Imposed on the right to freedom on the ground of public order, morality and health, has the right to establish, maintain. I think this will be the answer. D. It's taxable. No, not taxable. D. Okay. Any point of differing points you can give in your comments. Which of the following articles Constitution of India are exception to fundamental rights enumerated in Article 14 and 19? 31A, B, C. So 31A is there, C is there. C. 31A is compulsory acquisition of lands. In case of compulsory acquisition of lands, if Article 14 or 19 is violated, then it will not be considered violations and hence it will be valid. Article 31B is there also, which says that acts and regulations found in Schedule 9 shall not be subject to judicial review on the ground that they violate fundamental rights, but there is a deadline on April 24, 1973. Post April 24, 1973, the acts and regulations may be judicially reviewed if they pertain to violate the fundamental rights. It was declared confidently by the Supreme Court in IR Coelho case 2007. It removed the blanket immunity upon the 9th schedule. So answer will be C. Then question number 16. Pursuant to HN Sandal Committee, the Contempt of Court 1971 was passed. Yes, HN Sandal Committee was appointed by Government of India in 1963 and it recommended civil and criminal contempts. So contempt of court was not explained mentioned in the Constitution in details. Only 1902 mentions that contempt of court under which freedom of speech and expression can be restricted. The Constitution of India empowers the Supreme Court and High Court to punish for its own contempt. Article 129 and 129. Article 129 for Supreme Court and Article 215 for High Court deals with this power. The Constitution of India defines civil law. Indian Parliament has vested with the power to make laws on the contempt of court. Yes. So that will be correct. 1, 2, 4 will be the answer. B. With reference to question number 17, with reference to writs issued by courts in India, consider the following statements. Mandamus will not lie against private individuals unless it is entrusted with a public duty. Okay. Mandamus will not lie against company even though it will lie. So it is wrong statement. Any public minded person can be yes. So 1 and 3 will be the answer. C. Okay, 1 and 3. Under the Indian Constitution, concentration of wealth violates not right to equality, but 39C deals with Article 39C deals with deconcentration of wealth. Article 39C is seen as a socialist principles, and it deals with that the functionality of economic structure does not result in the accumulation of wealth in the hands of the eminent detriment to the common good. It directs the state. It directs the state it directs the state to say that the operation of economic system does not result in the concentration of wealth. So it is 39 small c in socialist principle. A constitutional government means a government, representative government of a nation with a federal structure, not necessarily federal structure, does not mean there may be unitary feature structure, that may be federal structure, that may be presidential government, that may be parliamentary government, so not fixed. A government whose head enjoys nominal power, that is not related to constitutional government. A government whose heads enjoys nominal powers, same option is there. Okay. Number D, a government limited by the terms of yes, that is called a constitutional government. A government subordinate to the constitution. So that will be B, that will be A, is D. Consider the following statements in respect of Bharat Ratna and Padma Awards. Bharat Ratna and Padma Awards. Just a minute. Okay. So let us see what are the main exceptions. Bharat Ratna Padma Awards are titles under Article 18(1)(a). That is not correct. I don't remember the case. That in Balaji case somewhere, it was a case in Supreme Court. The Supreme Court held that the national awards like Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri do not amount to titles within the definition of meaning of Article 18(1) of the Constitution, thus are not to be used as a prefixes or suffixes to the name of the recipient in any manner. So Article 18(1) abolishes titles, but these are not titles, the Padma Awards. The statement 1 is correct, is not correct. Padma Awards which were initiated in 1954, correct, but were suspended only once. No, it was not suspended only once, it was suspended in various times in 1977 and also under 1992, 1977 during Moraji Desai government, and also in 1992 it was suspended. So it has been suspended twice. Number of Bharat Ratna awards restricted to 5. No, it is 3. Statement 3 is correct, incorrect. 3 people can be asserted. And the total number of Padma awards to be conferred each hour is limited to 120, but the count excludes posthumous awards and any non-resident Indians, overseas citizens awards. So 120 Padma awards, but that excludes awards posthumous awards and NRIs OCH এগুলো সব এক্সক্লুড করা হবে। That was there. Then the answer will be not correct, not correct. So this is not correct. This is not correct. This is not correct. 1, 2, 3 are not correct. All 3 are not correct. Okay. 21 at the national level, which ministry is nodal agents to ensure effective implementation of scheduled tribes set of the traditional forest dwellers? Is marked 2000. It is Ministry of Tribal Welfare. Protects the rights of scheduled caste and scheduled tribes and other forest dwellers. It is minister. So it is also the protection of the interest of the scheduled tribes. This act has been enacted by Parliament. It's popularly known as right to forest. So D. A legislation which confers on the executive or administrative authority and unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Indian Constitution? What do you think? What will be the best answer in this regard? Which will be the best answer in this regard? No idea. Okay. Let me explain what is written here. A legislation which confers the power administrative confers executive and administrative authority unguided and uncontrolled power. Discretionary power. That means it will violate rule of law. Law will be equal, all are equal in the eyes of law. Law will not discriminate anybody. The state shall not deny equality before law and equal protection of law to any person on the basis of religion, race, caste, sex, place of birth. So it will violate Article 14. It will violate Article 14. Okay. Next question. Which one of the following in Indian presidential feature of that indicates a federal characters? Federal character means two things. Division of power must be there. Independent judiciary, dual government, dual citizenship. So let us see what is there. Independence of judiciary will be there. Yes. Union legislature is elected representatives from different constituent units. That is not only inherent or specific to federation. It is a democratic condition, democratic features. So that will be not correct here. Union cabinet cannot be elected representatives from regional parties. That is not a statement relating to this. Fundamental rights are enforced by court of law. That is another thing. So answer will be A. Independent judiciary. One of these options is correct. A. It is related to federation. In federation there must be independence of judiciary. Is safeguarded in the constitution. You will see in various articles the independence of high courts and supreme courts are secured by the constitution. Question number 24. Which one of the following best defines states? See, state contains 4 basic elements: territory, population, sovereignty and government. Okay, look at C. Community of persons permanently occupying a defined territory. Territory is there, independent of external control and possessing an organized government. So community of person is there, citizens, populations, at a territory, at a government, independence, external control is sovereignty, and a government, organized government. So 4 elements are there. I think the option A will be correct. Let us see other options. A politically organized people of a different territory. Okay. That is there, that possessing an authority to govern them, maintain law and order, protect their natural rights, safeguards there, but sovereignty is missing. In option 2, option A is correct, I think. Let us see option C. A number of persons who have been living in a defined territory. Territory is there, citizen is there. For a long period of time, their own culture, tradition, other parts are missing. Government is missing, sovereignty is missing. Sovereignty is missing, government is there. Society permanently living in a different territory, central authority and executive responsibility, that is not meaningful. So option A will be the correct answer. Option A will be the correct answer. Which article of the Constitution safeguards one's right to marry one's own choice? That is Article 21. Oh my God. 25 is there, right to marry. Okay, just a minute, let me okay. So I think the best answer will be Article 21, because 19 is freedom, 21 is right to life, includes 25 is freedom of conscience, so Article 21 will be there. B. Answer B, answer A. Now we come to question number 626. Okay. Now, okay. So these are the areas. Okay, let me explain 26. What do you think? What will be the answer? What will be the answer to question number 26? Okay. The prevention, the expression officer profit is mentioned in Article 102 and Article 191 of the Constitution. It has not been defined anywhere. Therefore, Parliament has enacted Parliament Prevention of Disqualification Act 1959, which exempts the children. That is correct. That is correct. And okay, the act was amended 5 times, right? Parliament has amended 5 times. That is the, if you correct state, is 1960, 1992, 1993, 2000, yes, 6, and 2013. The term officer profit is not well defined in the Constitution. So is that correct? 1, 2 is correct. Option A. 26. In the context of polity, which one of the following would you accept as the most appropriate definition of liberty? In the context of polity, which one of you, liberty means what? Liberty means what? Liberty means absence of restraint. That is the best definition. B. Protection against tyranny of political rulers. That is not liberty. That is rule of law. Opportunity to do whatever one likes. That is not there. So B will be the answer. Which of the following regarded as the main feature of okay. So what will be the next question? Go to your question. Next question is which one of the following? Which of the following is regarded as the main feature of rule of law? Rule of law. I think limitations of power will be there. Rule of law limits the power. Yes, equality before law will be definitely there. Okay. And liberty and civil rights. Yes. C will be the answer. Okay, C. Which one of the following reflects the nicest and wait a minute, sorry. Which of the following nicest is not visible? Like appropriate relationship. Nicest appropriate relationship between law and liberty. This is the nicest law, nicest aspect of the okay. What do you think? What will be the answer? What do you think? What will be the answer to the questions? Most appropriate, nicest definitions, relationship between law and liberties. See, if there are more laws, there is less liberty. That is a totally back statement. If there are no laws, there is no liberty. It appears to be right. If liberty is protected by law, liberty is protected by law. Or if you don't have law, then liberty of every people, every person cannot be protected. Okay. Number C, if there is liberty, laws have to be made by the people. No, that is not. That is an ambiguous statement. Laws are changed to open. Liberty is in danger. So best answer will be B. Best answer will be B. In the context of India, which one of the following is the correct relationship between rights and duties? look at rights are correlative. I think this is appropriate, looks appropriate. Then other options, rights are personal, hence independent of society and duties. No. Rights, not duties are important. Both are important. Duties, not rights are important for the establishment. No. Both are important. So this left out answer is option is A. So it will be A. Rights are dependent upon duties. One man's right is other man's duties. Says. Duties are also essential as rights. Duty towards the state, duty towards the environment, duty towards the community, collective duty. Fundamental duties enshrined in Part IBA is considered to be an essential part, although they are not enforceable, but they are essential preconditions for enjoyment of rights by other people. Hence, it is right to say one man's duty is other man's right, and the vice versa. Okay, guys, so we have completed 30 most important previous year questions, which will not only help you in understanding the question, but enhance your approach towards grasping the things, because you have to go deeper in interpreting the chapters of Constitution, not just have a surface idea. So I hope you are pursuing your preparation in this light. Okay, and on this class, if you have any comments to pass, then you can add it in our comment session, and the YouTube will definitely look at your comments and improve ourselves accordingly if it is a correct solution. Okay, thank you very much for watching. Have a good day and wish you all the best for your future endeavors. May God bless you. Thank you very much to all of you.